Summarise the judgment.
This case concerns the tort of private nuisance in the context of a major oil spill which occurred off the coast of Nigeria on the 20th of December 2011. The question at issue is whether there is a continuing private nuisance and hence a continuing cause of action. And this matters because the date of accrual of the cause of action is the date from which the limitation period, which is at most 6 years, starts to run. The claimant issued their claim form on the 13th of December 2017, which was just within the 6 years of the incident. But they have sought to amend their claim form and particulars of claim outside that 6-year period, and whether that is permissible is the principal reason why the parties are in dispute as to the date of accrual of the cause of action. The oil leak in question has become known as the Bonega spill because it occurred during a cargo operation at an offshore installation in the Bonega oil field. The leak was caused by a rupture to one of the flow lines through which the oil flowed. The leaking was stopped after about 6 hours, but by that time the equivalent of at least 40,000 barrels of crude oil had leaked into the ocean. The claimants, Mr. Jalla and Mr. Jaw, are 2 Nigerian citizens. They bring a claim in the tort of private nuisance for undue interference with the use and enjoyment of land owned by them, which they say has been impacted by the Bonega spill. It's being assumed, for the purposes of this appeal, that oil reached their land within weeks rather than months of the 20th of December 2011. The defendants are companies within the Shell group of companies. On the assumption that the oil from the oil spill is still present on the land of the claimants and has not been removed or cleaned up, it is submitted by the claimants that there is a continuing cause of action for the tort of private nuisance that is accruing afresh from day to day. That submission of the claimants, which is being dealt with as a discrete preliminary matter prior to trial, was rejected by Mr. Justice Stuart Smith in the High Court, and the appeal against his decision was dismissed by the Court of Appeal. The claimants now appeal to the Supreme Court. The Supreme Court unanimously dismisses the appeal. The judgment is given by myself, with whom Lord Reid, Lord Briggs, Lord Kitchen and Lord Sales agree. The judgment explains that in principle and in general terms, a continuing nuisance is one where outside the claimant's land, and usually on the defendant's land, there is repeated activity by the defendant or an ongoing state of affairs for which the defendant is responsible, which causes continuing undue interference with the use and enjoyment of the claimant's land. For a continuing nuisance, the interference may be similar on each occasion, but the important point is that it is continuing day after day or on another regular basis. So, for example, smoke, noise, smells, vibrations, and as in the recent case of Fern against Board of Trustees of the Tate Gallery, overlooking are continuing nuisances where those interferences are continuing on a regular basis. The cause of action therefore accrues afresh on a continuing basis. If the claimant's submissions were correct, it would mean that if the other ingredients of the tort of nuisance were made out and a claimant's land were to be flooded by an isolated escape on day one, there would be a continuing nuisance and a fresh cause of action accruing day by day so long as the land remained flooded on day 1000. But the Supreme Court rejects the claimant's submission. There was no continuing nuisance in this case, and there would be no continuing nuisance in the example of the one-off flood. And that is because outside the claimant's land, there was no repeated activity by the defendants or an ongoing state of affairs for which the defendants were responsible that was causing continuing undue interference with the use and enjoyment of the claimant's land. The leak was a one-off event or an isolated escape. The oil pipe was no longer leaking after 6 hours, and it's to be assumed for the purpose of this appeal that the oil reached the Nigerian Atlantic shoreline and hence the claimant's land within weeks rather than months of the 20th of December 2011. The facts of this case are therefore distinguishable from a tree route case such as Delaware Mansions Limited and Westminster City Council. In that case, in contrast to this, there was an ongoing state of affairs outside the claimant's land constituted by the living tree and its roots for which the defendant was responsible and which, by further abstraction of water through the encroachment of the roots, caused continuing undue interference with the use and enjoyment of the claimant's land. Moreover, acceptance of the claimant's submission would undermine the law on limitation of actions because it would mean that there would be a continual restarting of the limitation period until the oil was removed or cleaned up. It's not surprising that the claimants could cite no case directly supporting the position they were advocating, and while there may be no authority that directly contradicts that submission, it is contrary to principle and would have the unfortunate policy consequence of undermining the law of limitation. The appeal is therefore dismissed. By way of footnote and for completeness, I should add that it was being assumed for the purposes of this appeal, but without being decided, that the tort of private nuisance may be committed where the nuisance emanates from the sea, and that the tort of private nuisance may be committed by a single one-off event, such as the oil spill in this case. The defendants wished to challenge those assumptions by a cross-appeal, but permission was refused by the Supreme Court for them to do so.
The Court will now adjourn.